I believe that you are taking this meeting today. It looks like we have a number of new folks joining, which I always love to see. But I'm going to go ahead and hand it over to Wendy Lin of Long Partnership. She is, for those of you who are new to the group, Wendy is the co-chair of this group from the Asia Pacific region. And then our other two chairs, Philip for EMEA and Ryan for the Americas, are also with us today. So thank you for everyone, for joining. And I'm going to go ahead and pass it over to Wendy, who will be moderating today's discussion.
Thanks, Tana. Welcome everyone on behalf of myself, Philip, and Ryan. How we're going to plan the session today is three parts. First, we would hear from our colleague from South Korea in terms of enforcement of court decisions and arbitral awards. We'll have that for about 20 to 25 minutes, and we'll take some questions as well if we have time. And what we would do next is we would have an introduction from our member firm from India, Vaish, as to his firm and the kind of practices that they have and they conduct. And finally, we will have a short networking session before we close the session for the day. And before I hand over to Vijay, this is very interesting. We've heard since last year, we've been running a series of getting someone from each member country to present on enforcement of court decisions and arbitral awards. We've covered Mexico, Canada, China, Singapore, and now we will get to hear some practical insights from South Korea. And if I can hand it over to Vijay, it's always good and interesting to hear how enforcement of arbitral awards in terms of the grounds for resisting, we all know that they're quite similar, but in terms of practice and implementation, it might be different. And I think in terms of enforcement of court decisions, there is no uniformity across various jurisdictions. So it'll be very interesting to hear from you. I'll hand it over to you, Vijay.
Thank you, Wendy, and thank you everyone for this wonderful opportunity. My name is Ujay Kim. I'm a partner at Bae Kim and Lee, and my first time joining this wonderful group, and it's a sincere privilege for me to have this opportunity to give a very brief presentation on enforcement practices here in South Korea. And as you know, this issue is we can go on for hours about this issue, but given that I have 20 minutes, I'll keep it very short. And I'll give a very general explanation of how the system works here in Korea, which is a very arbitration-friendly jurisdiction, as you all know, and also present you with a couple of very, quite interesting recent cases, which shows how the Korean courts are moving with regards to enforcement of arbitral awards and foreign court judgments. So with that introduction, I'll start my presentation. So, okay, so this is my name. You see my picture here. I've been with BKL. We're a full service firm, about 600 lawyers, and I've been with BKL for the last 11 years. I do a lot of arbitration work, investment treaty work, commercial arbitration, but a lot of my work these days relate to overseas and domestic litigations, which because of the nature of the work I do relates to enforcement of arbitral awards and foreign court judgments. And we see a lot of complicated cases regarding enforcement cases these days, owing to the complexity that are added to arbitration proceedings nowadays. So those are some of the things that we see. And just moving on. So for my email from my colleagues and from from the group, I was asked to address two issues, and I think you can see the two issues on this slide. The first issue is with respect to enforcement of arbitral awards. What is the actual practice in South Korea? For example, how often does the Korean courts refuse enforcement based on public order arguments or public policy? That's the first issue. The second issue I understand is it possible to enforce court decisions in South Korea? Under what conditions? Or if there is a bilateral treaty, or what is the reciprocity requirement in Korea? Now, I will be addressing these two issues in order. And before I do that, I'd just like to reiterate that Korea is a very arbitration-friendly jurisdiction and is very active in terms of the firms, the practitioners in the arbitration world. And with that, for the first issue, so in terms of arbitral awards, so we always start off, I think, based on Article 36.2, subsection 2 of the Korean Arbitration Act, the KAA. And the act provides that a court may also set aside, when it finds that its own initiative, that the subject matter of the dispute is not arbitratable under the laws of Korea, or the law is in conflict with good morals and other forms of public policy of Korea. Now, I think we'll find this wording quite familiar because Korea is one of the countries that adopted the model law at its very early stages. So I think it'll be the wording that you see here is quite similar to some of the laws, like, or the terms, like, that you find in other jurisdictions. And based on that model law friendly, arbitration friendly jurisdiction, in a very seminal case in 1990, the Korean courts adopted somewhat of a very narrow interpretation of public policy for purposes of refusing to enforce an arbitration award. So the court essentially said that the so-called public policy exception to the enforcement of an arbitral award was intended to only protect only the most fundamental moral beliefs and social order in enforcing country. So it limited the scope or the reasons for refusing to enforce an arbitral award. So this is and this seminal case that was rendered in 1990 still stands as the controlling precedent in the Korean Supreme Court. Now, based on this basic, I think, like, seminal case or standing, what the Korean courts have held is that even when the foreign laws applied in an arbitration are in violation with the mandatory provisions of Korean law, this will not per se constitute a reason to refuse enforcement of awards in Korea. And and only where the actual result of recognizing or enforcing such an award would be contrary to the fundamental morals or basic concepts of justice in Korea should enforcement be refused. So this is the very basic position of the Korean Supreme Court with regards to the elements that constitute public policy in terms of refusing to enforce arbitration awards. Now, just moving on to, I guess, some of the recent cases based on the very basic principles that I've just discussed right now. The first case I think I'd like to introduce to everyone was rendered in November of 2018, approximately 3 years ago. And in this case, the plaintiff and the defendant entered into a license agreement pursuant to which the defendant was granted a right to produce and sell products based on the plaintiff's patent. And the plaintiff notified his intention to terminate the license agreement due to the defendant's failure to fulfill contractual obligations. But as we all know, and the story goes, that the defendant during the course of the arbitration proceedings, in a very unforeseen manner of events, applied for registration of the subject matter patent rights in Korea. Now, having met with this situation, the plaintiffs in turn commenced formal arbitration proceedings against the defendant, claiming for the return of patent rights and the reimbursement of damages that it suffered. And this case was quite interesting in the fact that it was heavily disputed on whether an arbitral award had the power to impose indirect compulsory damages, i.e. penalty. And if one takes the view that allowing penalties or indirect compulsory damages is within the sole purview of domestic courts, there would have been a ground for refusing such kind of an arbitration award that ordered penalties based on public policy. But in this case, what the court said was that, so the defendant actually made that argument, but the court essentially rejected the defendant's argument and ordered the enforcement of the arbitral award, meaning that the court endorsed that the plaintiffs, I guess, the plaintiff endorsed the view that an arbitral tribunal is also empowered to levy penalties against in an arbitral setting, notwithstanding the fact that there are no explicit laws to that effect under the relevant laws here in Korea. So the holding somewhat reflects the Korean court's position that it allows, and it sort of it gives a very narrow meaning to public policy in refusing arbitral awards in Korea. So this is, I guess, one of the most, I guess, interesting cases that have been recognized with regards to enforcement of arbitral awards here in Korea. The second case I'd like to introduce to the group is not a recent case, I would think, like it's been some time, but when you ask a Korean lawyer whether there has been any known cases where the Korean Supreme Court has refused to enforce an arbitral award based on public policy, I think some of the answers that you'll get is no. There are no known cases. So that's how narrow the Korean courts determine public policy, but not very well known to, I guess, the legal society. But there are a couple of cases that were rendered in the lower courts in Korea that cited public policy in refusing to enforce arbitral awards. And this is one of them, and it was rendered in 2008. And in this case, the plaintiff and the defendant entered into a chartering agreement through their respective agents. However, due to delay in the plaintiff's shipping schedule, the plaintiff engaged a third party to provide the chartering service to the defendant. Now, after this was done, the defendant made the payment to the third party and subsequently refused plaintiff's request for payment for service fees rendered pursuant to the chartering agreement. Now, for reasons unknown, the plaintiff still initiated arbitral proceedings against the defendant, and the defendant refused to engage in the process of constituting a three-member tribunal, despite being notified of the proceedings, and the arbitration was conducted by a sole arbitrator who determined in favor of the plaintiff. Now, the plaintiff brought this arbitral award against the defendant in the Korean courts. And unfortunately, for reasons also not very well known, the defendant contended their primary argument was that there was no valid arbitration agreement between the parties. And this primary argument was, I guess, like rejected by the court, where the court held that the governing law with respect to the validity of the arbitral agreement was English law in this case. And under English law, the arbitral agreement in this case was valid. That was the court's decision. But that being said, the court in this case found in favor of the defendant in terms of the application of public policy. And what the court actually said was that, as you see from the slide here, they refused enforcement of the award on the grounds that allowing enforcement would violate public policy. And the reasons for that was that because the defendant had already made payment for services to the third party, thereby obtaining a right to claim reimbursement of that payment for the plaintiff, ordering enforcement in these circumstances, the court saw would be in breach or in breach of public policy here in Korea. So this is one of the very rare cases that the court actually cited public policy in refusing arbitral awards, as you can see from here. And also, the court also, I guess, considers certain other factors, including the fact that the combined amount of the defendant's reimbursement claim and damages exceeded the claimant's claim. And based on that, the court refused to enforce the arbitral award. So this case is a very rare case rendered in the Korean, the appeals court. But if you ask me if there's any known court, like rendered known decision or judgment rendered by the Korean Supreme Court in terms of refusing to enforce awards based on public policy, there are very few or not known cases on that front. So I think that's one of the things that I'd like to point out. Just moving on to the second issue with regards to court judgments rendered in foreign courts. So I guess, like, you know, the issue here relates to reciprocity. And you see from the slide here, Korea is not a party to any bilateral or multinational treaties for reciprocal recognition or enforcement of foreign judgments. Now, that being said, being a very arbitration-friendly jurisdiction, Korea has its own principle to recognize and enforce foreign judgments in law and court precedents. And Korean courts are basically very generous in recognizing and enforcing foreign judgments based on the principle of reciprocity. So what constitutes reciprocity here in Korea? The law starts from Article 217 of the Korean Code of Civil Procedures, and you can see the text here. I'm not going to read it to you, because it's very similar to what you see in other jurisdictions. And like, for instance, the second point being there being legitimate service of process and not being against good morality or public policy in Korea, and there not being substantial difference in recognizing final judgments between Korea and the country to which the foreign court belongs. These are some of the requirements. So we sort of break it down and simplify what the law sort of states here in Korea. In sum, reciprocity is recognized where under conditions that do not differ is significant aspects from the conditions required by Korean law for the recognition of Korean foreign judgments. And I think the second point has some meaning also, where once a foreign country's conditions, according to the foreign country's legislation precedents, have been compared and approved, the Korean courts are quite generous in recognizing reciprocity. And the third point being a treaty between the foreign country and South Korea is not necessary in recognizing reciprocity. So these are some of the traits that you'll recognize here in Korea. And these are some of the, and you see here, again, the Korean courts are quite generous, and these are some of the jurisdictions that you see here, as in state of New York, the province of Ontario, Japan, Taiwan, have been explicitly recognized to have reciprocity in Korean court precedents. So these jurisdictions have been expressly recognized by the Korean courts. Now, just very similar, I think, to other jurisdictions that have adopted model law. So moving on to some of the recent cases. So it has one of the issues that has always been, I guess, disputed in Korea with regards to enforcement of foreign court judgments is whether it is against public policy to enforce foreign court judgments that have ordered punitive damages. That has been always a point of discussion. And as you see from the slide here, the lower courts have previously held that the award of punitive damages may be against Korean public policy, especially in the Korean civil law system, which only allows compensatory damages as a result of torts. That has been a very long-standing principle in the Korean court legislation, Korean court precedents. But being a very friendly, arbitration-friendly jurisdictions, we have seen the court moving toward a more open stance with regards to this issue. So, but in this case, which was rendered very recently in March 11 this year, the Korean Supreme Court said that the Fair Trade Act, the amended Fair Trade Act allows for damages in an amount not exceeding 3 times the actual damages. So they recognize that even under this Fair Trade Act in Korea, punitive damages are allowed. And therefore, as somewhat of a byproduct of that, to the extent that, so as you see from this the slide here, that what the court essentially found was that should the act for which the punitive damages were awarded fall under any area of regulation by respective legislation that allows damages in excess of compensation damages in Korea, punitive damages, the enforcement of punitive damages are allowed. So basically, what the Korean Supreme Court said that to the extent that the relevant law here in Korea recognizes punitive damages, even if a foreign court judgment renders or orders punitive damages that can be enforced in Korea. Now, you may think that like, of course, like, that would be the way to go, like, but given the long-standing position that the Korean court like held with regards to punitive damages, which is quite exceptional in the Korean legal system, which is based on, as I just explained, compensatory damages. This is quite a shift by the Korean courts. And by way of that, as you see from the slide, the Korean courts effectively decided that enforcement of a foreign judgment awarding punitive damages can also be allowed if punitive damages are allowed in specific area under South Korean law. And this judgment has meaning because you see from the slide here, there have been, I guess, quite a rise in the number of, I guess, laws here in Korea that have ordered punitive damages. Of course, Korea is a civil law system, but is also very open to adopting common law traits. And by way of that, create certain laws with respect, especially regarding fair trade laws, have been quite active in adopting and ordering punitive damages. And so given the number of Korean laws like that allow for punitive damages, the scope that enforcement would be allowed for foreign judgments that order punitive damages have arisen significantly. So that is, I guess, like the meaning like that you would draw from this Korean court recent case. The second case, I think, like is I think it's a bit easier. But what the court said was that so this is a case where a California court rendered its decision. It was enforced, but the underlying legal, I guess, relationship changed after the enforcement judgment or the enforcement decision was rendered. And by way of that, it was, I guess, disputed whether the parties could take action that reflected developments after the enforcement decision was rendered. And what the court decided here is, as you see from the slide, the enforcement decision should not preclude a claim seeking deregistration or something that comes opposite to what was decided in the relevant Californian decision court. So what the court said was that a South Korean court's enforcement decision has no determinative effect on the substantive claim of the foreign judgment, but merely renders the foreign judgment enforceable in South Korea. And therefore, even if a enforcement decision becomes conclusive and is executed, it can be newly disputed depending on the progress of the substance-based proceedings in the foreign jurisdiction. So so this was somewhat of an issue that has always been disputed, but the Korean courts took a very clear view on the scope and the effect of an enforcement decision that is rendered in the South Korean court. So I guess this is some of the second case that I'd like to introduce as a recent development in Korea. Yes, so this is somewhat reiterating what I just explained. So yes, so I think my 20 minutes is up, but I hope my presentation was helpful in giving a very brief summary of the positions and the principles that underlie the Korean system with regards to the enforcement of arbitrary awards and foreign court judgments. And I don't think I can answer all the questions, but happy to take any questions that anyone may have on my presentation. Thank you very much.
I think we probably, thanks, Vijay. I think we probably have time for one or two questions, and I would just like to see if anyone has any questions for Vijay. If not, I have a question. Vijay, I noted from your presentation at the start, the wording of the Korean Arbitration Act provided that the court can, on its own initiative, set aside arbitral awards on grounds that it is contrary to the public policy of Korea. I thought the insertion of the words "on its own initiative" was quite interesting, and that's not usually seen in the model law or the acts of many of the model law countries. Is there a reason for it? And do you actually think that the court will, on its own initiative, set aside awards, even if parties don't actually raise the point of public policy?
I think somewhat as a practical matter, like, Wendy, like, as you know, like, better than I do, like, like raising a public policy defense, like, is a given, it's a fallback, like, argument, like, so I think in a practical level, like, I don't think you'll see many cases where the parties don't argue that point and the court sort of bring that point up, like, I'm not sure if like you'll see many cases on that, like, but like, the reason why the law or the Korean, like, courts sort of take that position is that public policy here, like, is something like, an issue that relates to mandatory law. And in Korean law, like, if it's a mandatory law, the court, like, in certain circumstances, like, can investigate the cause or the existence, like, of such, I guess, like, reasons or causes, like, based on its own initiative, as in an ex officio, like, basis, like, so that's what's reflected in the law that you just mentioned. But as I said, but like, but again, like, but at a practical level, like, because this is somewhat of a fallback argument, like, I'm not sure if that will happen very often, but yes, the courts are empowered to sort of look at that, like, cause of refusal, like, if it chooses to.
Thanks, Vijay. I think if anyone else has questions, we could always, email Vijay. There's nothing stopping us from communicating with one another, even outside of this discussion that we have once in a couple of months. Perhaps with that, if I can hand over to Vinay to give us an introduction to his firm.
Yeah. Good evening and good morning. I don't know how many of you are in places where it's morning, early morning. Here in India, it's evening time. So hello to everyone and thank you for giving us the opportunity to present our dispute resolution team. Although the time given is short, so I can't possibly introduce all my team members, but I'll just put up a presentation if I can, just share the screen with you. We are, 1 minute. So our firm has been, it was incorporated in the year 1971. We have completed 50 years last year. And out of those 50 years, we have been full service firm for about a good 35 years. Earlier, we were into tax litigation, but for the past 35 plus years, we have been a full service firm. We have offices, main offices in New Delhi, Mumbai, and Bangalore. The total strength is about 10 partners and 100 plus associates. Coming to the areas of dispute resolution that we cater to our clients, it is civil, contractual, and commercial litigation. Arbitration is both domestic and international. Insolvency litigation is something which is, has become very prominent and very prevalent at this time because a new statute came in 2016, and now it is gaining popularity with business community, and a lot of issues are coming up. Then we have a team which does white collar crime and criminal litigation. Then tax litigation, both direct tax and indirect tax. Transfer pricing litigation is a big piece that we do. Intellectual property rights and information technology. These days, we are having a lot of litigation in the areas of cybercrime and data theft and privacy laws. So we have done some interesting matters in that area. Real estate is a big area of litigation because a new act came into being a few years back, which was actually aimed at, controlling the builders, but that act has raised many issues and a lot of litigation. Competition law or the antitrust laws is also an area which we do, employment and labor and general laws. Now our team practices across all states all over the country. So wherever required, the team members travel to different areas. different places, different courts. We represent matters before the Supreme Court, all the high courts, civil courts, criminal courts, and various regulatory bodies and tribunals all over the country. And few of our attorneys are registered as advocates on record who are qualified to file petitions before the Honorable Supreme Court. Now, in India, what happens is that in the Supreme Court, only counsels who are qualified as advocates on record can file petitions. Otherwise, a non-advocate on record cannot file petitions. So we have a couple of attorneys within the firm who are qualified, so that gives us an added advantage that we can file petitions to the Supreme Court and we don't have to engage people from outside to do that. Now, some of the key members of our litigation team, I have been with the firm for about 36 years. My areas of litigation practice is corporate, civil, commercial, tax litigation, and advisory. Similarly, Mr. Daruwala is also, apart from advisory, he's also into litigation, corporate, civil, commercial, tax, and advisory. Then I have Mr. Vijaypal Dalmia, who is specializing in intellectual property rights, white collar crimes, civil litigation, and commercial litigation and arbitration. So then we have Sandhya Iyer, who's also attending the meeting today. She will be presenting a few interesting areas that our team has been handling litigation for your knowledge. We will share some areas that we have been doing, which will be interesting. She mainly does corporate banking, securitization, and insolvency and bankruptcy litigation. Now we have Kavita Jha, who is also a partner. She mainly does tax and commercial litigation and arbitration as well. Melvin Fernandez is an associate partner. He does IPR litigation, corporate, commercial, disputes, and insolvency, bankruptcy, and arbitration. Rajat Jain and Kaustav Prakash are both principal associates. They do IPR, white collar crime, commercial litigation, corporate and civil. So these are some of the key people. We could not put all of them in the list. Now, as I said, the principal offices are New Delhi, Mumbai, and Bangalore, but the reach of the dispute resolution team is throughout the country, and we regularly handle matters before high courts, district courts, tribunals across the country. We have a network of councils in other states that we work with and engage services for clients in other states. When I say that, in India, we have a few states which only allow locally registered attorneys to file matters in the local courts. So that is the reason why we have to have a network of local attorneys who will help us file those matters, although the arguments and the actual litigation is carried out by the dispute resolution team from the 3 offices or wherever it is required to travel. Now, the key members of the dispute resolution team are very ably, assisted by other attorneys in the firm who have, knowledge and expertise in the areas where the litigation is happening. Say it is a litigation in the area of intellectual property or tax or commercial litigation. So some team members who really understand those areas and subjects pitch in and become part of the team to help the litigation team, prepare matters and take it forward. So that is how we are able to deliver to our clients in a cost-effective and a timely manner. So that's a short introduction of our team. This is just a snapshot of few of the members. This is our 3 offices. New Delhi, Mumbai, and Bangalore. So that's as far as my presentation is concerned. I will request my colleague Sandhya to tell us about some interesting matters that we have been handling. I'll just stop sharing just a minute.
Hello, everybody, and thank you very much for this opportunity to present our litigation practice. I will quickly run you through some of the interesting assignments that we have been handling. So one of the important assignments that we are currently handling is the one relating to National Spot Exchange Limited. Now, this was a commodity exchange, and somewhere prior to 2022, they were entering into what was called repurchase contracts. And the regulator held that such repurchase contracts are not permissible. They are in the nature of lending, and they prohibited them from entering into such transactions. So the consequence was that the exchange defaulted on its obligations to the extent of nearly 54 billion rupees, which is around 675 million US dollars. And apart from this one defaulting, their operations also came to a halt. Now, when I say defaulting, when an exchange defaults, what happens is that there are many people who have traded on the exchange and there are settlement obligations due to them. So all these people, whom we will call investors, filed a suit against our client, which was the exchange, in the Bombay High Court, and for recovery of the money. So what the stand that the exchange took before the Bombay High Court was, look, I am an exchange. I have not sort of siphoned off the money or taken away the money. These are amounts due to the investors. But please remember that I too have to recover money from people who have defaulted with the exchange. There are brokers, there are the sub-brokers who have defaulted with the exchange, and I have to recover money from them. I recover the money and pay it to the investor. So that was the stand taken, and it was very much appreciated by the High Court. And there was something unique which happened in this case, which you may not see in too many other matters in India. The Bombay High Court set up a 3-member committee, which was headed by an ex-retired judge. And it also had a lawyer as a member, as well as a chartered accountant as the member. And they were given the responsibility of examining. They said, okay, the exchange has to recover money from various defaulters. In the normal course, you'll have to go and file suits against these defaulters. But instead of that, there were third-party notices given in the main suit filed by the investors itself. And this 3-member committee had the responsibility of examining the records of both the exchange, the books of the exchange, as well as the records of all the defaulting members. And they will determine the amount that is payable by the defaulters to the exchange. So once the committee determines the amount payable, they will prepare a report, and this report is presented to the Bombay High Court. And once it's presented to the Bombay High Court gives another opportunity to the defaulters to raise any objections. And thereafter, once the Bombay High Court is satisfied, they will pass an order directing the defaulters to pay the amount to the exchange. It is paid into a kind of escrow account, and the monies are collected in order to meet the obligations of the investors. So this is a kind of unique arrangement which you may not come across too often in India. Now, once you get these orders from the Bombay High Court, you have to enforce it as a decree against the various defaulters. India is a country which has 28 states and 8 union territories. So you'll have to go, the exchange will have to go to all these places and enforce it, which could be a very cumbersome task. So what the exchange did was they approached the Supreme Court of India and said that please set up a committee here in Delhi. And the Supreme Court accepted that, and a committee has been set up headed by a retired judge again. And this committee, single member committee, has been given extensive powers of an executing court under the Code of Civil Procedure, and it will oversee and ensure the enforcement of the various decrees that the exchange obtains. And this way, a kind of solution is worked out where the exchange is able to recover money from the defaulters, and the money that is collected is used to repay the investors. So both these arrangements of the committee at the High Court level at Mumbai, as well as the Supreme Court committee, these are unique. One doesn't come across them very often. And this is one of the matters that we are currently handling. Now, to quickly come to some other matters, we handle arbitration, different types of arbitration proceedings as well. And one of the arbitration proceedings that we are handling is for an international large multinational foreign company. They are our clients. So what had happened in this case was an Indian joint venture partner had filed proceedings for recovery of some money from our client. And this was an arbitration proceedings in Singapore under ICC rules. In Singapore, the award was against the joint venture partner and in favor of our client. So I believe challenging the award would have been very difficult for the this joint venture partner in Singapore. So they tried some mischief. What they did was they tried to come and challenge the award in India, claiming that this is a domestic award in India. And for that, they tried to rely. Unfortunately, in this case, the arbitration clause did not clearly mention which was the seat of arbitration. It merely said that arbitration is conducted in India. So they used to try to exploit the clause to state that because of this clause, the Indian courts have jurisdiction. I am entitled to challenge this award in India. So we opposed it on the, in fact, this is an ongoing matter, and we opposed it on the ground of maintainability. And see, the law is very clear in India that if you can establish that the seat of arbitration is overseas, it's not in India, but is in a foreign jurisdiction, then you cannot challenge that award in India. It has to be challenged in the place where the seat of arbitration is. So we took up this argument. The arbitration clause was a challenge. So we had to rely on the pleadings of the parties in the arbitration proceedings in Singapore, as well as the ICC rules, to establish that the seat, though it's not expressly mentioned in the arbitration clause, parties had agreed that the seat of arbitration is Singapore. And at least we are expecting the order maybe by the end of July. And we are very hopeful, at least from the reaction of the judge and the general body language, that this decision will be in favor of our client. We are hopeful it will be decided in favor of our client. So apart from this arbitration, we have one of our clients who provides ATM services to various public sector banks in India. They have disputes relating to payment, wrongful deduction from fees due, or sometimes wrongful termination of contract. So we have been handling these arbitration. Currently, we are handling these arbitration proceedings as well. Then, as Vinay mentioned, there is the 2016 Insolvency and Bankruptcy Code. So we help a lot of banks and financial institutions in recovery of money. Before 2016, most banks for recovery of money would go to the debt recovery tribunals, which were tribunals set up under Recovery of Debt from Banks to Banks and Financial Institutions Act. It is renamed as Recovery of Debt and Bankruptcy Act in India. Now, initially, this was a 1993 Act, which in the first 2-3 years was very effective, and we have been successful in getting recovery certificates and judgments, anywhere between 1 to 3 years. But over the years, the institution has become a little inefficient because of vacancy of members in the tribunal and the large number of cases that have been filed by the banks and financial institutions. So in 2002, there is another legislation that was introduced, which is SARFAESI, and that is Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. This is a statute that helps banks, financial institutions, and certain categories of notified non-banking finance companies who have security created in their favor. So without the intervention of the court, there is a set procedure under which they can go and enforce their security. And many banks and financial institutions have been using this act, and we do advise them on this. So this is another area where we are practicing. In 2016, the Insolvency and Bankruptcy Code 2016 was introduced. And this is very much similar to the insolvency and bankruptcy laws in many of your jurisdiction. So just to give a broad idea, if there is a default of say 1 crore rupees, then what happens is the lender can file proceedings before the National Company Law Tribunal. And once the tribunal admits it, there is a resolution professional who's appointed to take over the assets of the company, manage and control the assets and the operations of the company. And this is a creditor in possession model. And he is given a time period of anywhere between 180 to 330 days to try and resolve and find a buyer for the company. If he is successful, then the bidder has to be approved by the financial creditors, who are called the committee of creditors, by a majority of 67%. Once the committee of creditors approve a resolution plan by a bidder, their commercial wisdom is respected, but it has to formally be approved by the National Company Law Tribunal. And the National Company Law Tribunal will merely see that this resolution plan is in accordance with the code. Now, if suppose there is no resolution plan approved by the Committee of Creditors or the National Company Law Tribunal, what happens is the company goes into liquidation. Now, in liquidation, initially many of the creditors prefer that you make an attempt for the first 3 months to try and sell the company as a going concern. If you are unsuccessful, not able to sell as a going concern, then you sell it on a piecemeal basis. So we have been representing the resolution professionals, the liquidators, then applicants who have been filing proceedings against defaulters. So in the entire gamut, we have been representing parties in litigation. Just to give you an idea of the interesting assignments that we have done, we have acted as the legal advisor for the resolution professional in the case of resolution of Garden Silk Mills Limited. And the interesting part about it was the whole resolution, including approval of the Committee of Creditors and the National Company Law Tribunal, was done within a period of 7 months from the date of admission of the proceedings, which must be one of the fastest for a company of this size. So this was one interesting matter. Another interesting matter was in the liquidation proceedings of a steel company. The liquidator was attempting to sell the company as a going concern in accordance with the instructions of the Committee of Creditors. Now, our client was interested in acquiring the assets or acquiring the company as a going concern, but for some reason they could not participate during the sale process in liquidation. And there was some other person who, there were others who participated in the e-auction process in liquidation, and there was some other party who was declared as the successful bidder. So our client thereafter was keen on acquiring this company, and we were looking for ways in which, because once in liquidation proceedings, a company is sold or the assets of a company are sold, the only ground on which such an asset can be sold, and that is settled law, is if there is fraud or material irregularity. So we had to look for any instances of fraud or material irregularity if we wanted the sale to be set aside. And what we found was the bidder, the company was engaged in the steel business and to be sold as a going concern, but the bidder in this case was a company which had a very nominal share capital, no prior experience in the steel business. And therefore, we took up the argument that how can such a company run a steel business? How can they take over the 2,000 odd employees of the company? It is not feasible at all for such a company in a real estate business to run a steel business. And our arguments, we were successful in our arguments, and the sale by the liquidator was set aside. Currently, both the liquidator as well as the successful bidder have challenged it before the appellate authority, and it is pending before the appellate authority. So this was another interesting order that we were able to secure. And
Sandhya, sorry. Thank you very much.
Yeah.
I'm just looking at Hannah to see if we have we're running out of time, and if probably we are, and if you could just wrap up in the next minute, because we do have a networking session.
Okay. So the other kinds of matters we do handle is labor disputes. I will not get into the details, but different kinds of labor disputes are also handled by us. I think I will wrap up with that since time is short. Thank you.
Thank you very much. Thank you. Hannah, over to you. I think you're going to break us up into groups for networking.
Yes, and I will give you 10 minutes. If for whatever reason you have to pop off, that's fine. Go ahead and do so. Make sure that you say goodbye to your person when you do. I'm giving you 10 minutes. You'll be placed into a room with 1 or 2 others, and you'll get a little pop-up on your screen. Just go ahead and accept it, and it will send you into a room.